Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion in estate planning. Join Tom and I as we break down the essentials of wills, trusts, long-term care, and legacy protection. I am your host, Kevin Rosenquist, and today we're going to talk about where to start understanding estate planning and probate. Tom, great to have you here. Thanks so much.
Oh, thanks for having me.
So if I've never done any estate planning before, what's my first step?
First step is to make sure you have the basics in order. And I've told people this for the 35 years that I've been in practice, that regardless of your age, whether you're 18 or 98, regardless of your financial background, whether you have $10 in the bank or $10 million in the bank, everyone needs to have three core documents. The first is a will. The second is an advanced medical directive. And the third is a general durable power of attorney. What a will does, it basically states that upon your death, your assets that you've accumulated during the course of your lifetime will be distributed to your heirs, and it appoints somebody, an executor, to basically carry out your wishes. Now, depending on the sort of will that you have, we could also appoint trustees to take care of distributions to minors or people that have special circumstances or needs. And if there are minor beneficiaries, minor children involved, we could also appoint a guardian. Now, the other thing that occurs is an advanced medical directive. An advanced medical directive, there's actually three types. The first is a living will. The second is a healthcare proxy. And the third is a healthcare power of attorney. The proxy is kind of a useless tool, so I've gotten rid of those a long time ago. But I do combine the other two documents into one. Healthcare power of attorney is a document where basically you're appointing someone to make decisions for you, medical decisions, if you're deemed to be incapacitated and cannot make them yourself. And that can be any sort of decision. Living wills in New Jersey became a thing back in 1992 with the passage of the Patient Self-Determination Act and some other related legislation. And initially the focus on this legislation was for end-of-life decision-making, because this all arose primarily from two court cases that arose over the years. First, back in the 1970s, we had the case regarding Karen Ann Quinlan, and then the second case was the Nancy Cruzan case that went to the United States Supreme Court back in 1990. And the nutshell, the court said, we have the right to make a determination in advance of how medical decisions should be made on our behalf if we're unable to make them. And within a couple of years, all 50 states decided to pass legislation allowing people to make these decisions. Initially, the focus was end of life. But as we know, we have a lot of people, especially those that are in nursing homes at the end of life, that they're not mentally competent to make day-to-day decisions, and they need someone to make those even if they're not life or death decisions. And the last thing is a general durable power of attorney. And that's where in between the time you execute a document and the time you die, if you happen to be incapacitated primarily and are unable to take care of your personal and financial affairs, it allows somebody to take care of them for you. They're primarily a financial document, although there can be some personal authority provided in those as well.
Yeah, it's interesting because I feel like a lot of times people think, oh, I don't need any of this. I'm young, or I don't have any assets right now. I don't need this stuff. But just listening to you describe it, it doesn't always have to do with assets. You're talking about medical decisions, end of life decisions. I mean, these are important things.
Yes, and the irony is that a lot of people don't think they need to plan. And really, if you take a look at the statistics, about half of our country doesn't do anything. Right. It's for a variety of reasons. Some people are just superstitious. I think as soon as they sign the will, they're going to be dead in 2 weeks. And some people, they just don't want to deal with it because it's unpleasant. I mean, who wants to sit around during their daytime thinking about death, feeding tubes, and mental incapacity? It's not a pick-me-up. On the other hand, I tell people you can plan voluntarily or involuntarily. So voluntarily is when you take the time and the effort to sit down with somebody that knows what they're doing and get a good will, a good healthcare directive, and a good power of attorney. What happens when you don't prepare, then things can go awry. So, for example, number one is the will becomes the intestate charts. And the intestate charts basically is how the estate is divided by the state's rules if you don't have a will. And I've never, in 35 years of practice, ever had someone come up to me and say, you know what, I want my estate to be distributed just the way the state of New Jersey has set forth in its statute. I mean, for example, in many states, when you pass away, you could be married for a number of years and have children, but you wind up seeing the estate divided between the spouse and the children. And most people, especially if they have a happy marriage, want everything to go to the spouse. New Jersey has modified their legislation of that. But nowadays, half of our marriages fall apart, and as such, we have lots of blended families. And the statute for the blended families, frankly, doesn't make a whole heck of a lot of sense.
Mm-hmm.
And that's not a crack at the legislators. That's just making sure you take care of your own affairs when you can. Now, the other thing also is with the medical directive and the power of attorney. What happens if you become incapacitated and you don't have either document? Typically, what needs to occur is a guardianship. And a guardianship basically is what we refer to as court-ordered surrogate decision-making. Basically, because you decided not to get a living will and not get a power of attorney and you're incapacitated, somebody has to petition the court and they have to ask that you be declared mentally incapacitated and that they be appointed as a guardian to handle your personal and medical and financial affairs. And that's a cumbersome and expensive process because first in New Jersey, you have to have 2 doctors certify that you're mentally incapacitated. And then someone, typically spouse, children, other loved one, is going to file a petition with the court and they will get a court date set up. You have to disclose all of your assets, all of your income. So that's what you should be. Your own private business becomes the business of the court.
Right.
And then what occurs is after the court sets a date, after reviewing the pleadings, 3 things occur. 1, anybody in the family is entitled to notice of the proceedings. And a lot of times, unfortunately, we have many families where there are individuals that are estranged or distant or hostile, but they get notices of these proceedings, and things that would otherwise be kept private from folks that you're not getting along well with are now A1 knowledge for them.
Mm-hmm.
Then on top of that, the person who is going to be declared incapacitated, i.e. you get served by a process server. And then third, the court appoints an attorney who's to represent your interests. Typically, these will go through quite easily, but even when the easy ones go through, probably in this neck of the woods, when you put in the cost of the court-appointed attorney, the attorney who files the petition, and the out-of-pocket cost, we're looking at somewhere in the ballpark of $5,000. Unfortunately, more and more over the years, we've had horrible contests. I was in part of one that in Burlington County, I imagine between all the attorneys that were involved, the dispute probably cost the family well over $1 million. I'm in the middle of one in another county right now in New Jersey where between me and the plaintiff's attorney, I'm sure we've already blown through $100,000 because of 3 brothers and sisters that can't get along.
Oh, boy.
So sometimes that happens just to family discord, but unfortunately, many times these arise because someone never got around to planning.
And another one we haven't talked about yet that becomes an issue is, of course, probate, which is a word that people are kind of scared of. Can you sort of describe or just kind of go through what exactly probate is and the challenges that families face along the way?
Okay, well, probate basically is the court's oversight of the estate administration process. And in many states, the word probate is kind of the equivalent of using the term boogeyman. People get understandably concerned because, for example, if we were in sunny Florida, probate means you're going to hire an attorney for even the most simple estate. You're going to pay them a fair amount of money, and it takes a fair amount of time. We have a lot of clients that have second homes down in Florida, and when they are owned in their individual name, just to get rid of a simple condominium or a simple second residence, it's a few $1,000s without the blink of an eye. In New Jersey, fortunately, we have the single easiest probate state in the country. There was a survey done about 25 years ago by the National Academy of Elder Law Attorneys, and they announced at the conference that year that New Jersey had the easiest probate state. Basically, when somebody dies as a resident of the state of New Jersey, if everything is properly prepared, the executor makes an appointment with the county surrogate, which is the office that takes care of the probate of wills in New Jersey. The appointment takes all of about 20 minutes, and it can be done 10 days after an individual passes away. And the executor needs to present the original will, a certified copy of the death certificate, and then typically either, depending on the county, some will ask you to do the paperwork in advance, some will actually do it on the spot. But after that and a filing fee of about $150, $175, give or take, that's probate in New Jersey. There are 2 requirements that are set forth. One is that within 60 days, the executor has to send a notice to anybody who's listed as a beneficiary under the will, as well as anybody who would have inherited under the laws of intestacy. So, for example, mom and dad have 3 children and 2 of them are going to be cut out for, improper conduct. Those 2 have to get a copy of a notice of probate. The notice of probate says 2 things. One, on X date, the last will and testament of the individual was submitted to probate and the particular executor was appointed to serve by the county surrogate. And then the second thing is that a copy of the will is available upon written request without charge. Now, quite frankly, most people like me change that second sentence to say, here's a copy of the will. We don't need to be billing people, 2 letters when we can get away with doing it for one, because I don't know of any cases where somebody doesn't want to see a copy of the will. But the probate process in New Jersey is very, very easy. The second requirement is that you have refunding bonds and releases executed and filed to terminate the estate. Now, frankly, in many counties, those two are not even enforced, but they're very inexpensive to do. So one thing people should be aware is that if everything is prepared properly, if a properly prepared will, then getting a will admitted to probate is extraordinarily easy. Quite frankly, you do not even need to have an attorney go to the county surrogates with you. I've jokingly told people for the amount of my hourly rate, I'll be burning in hell the first time I charge somebody to go to the county surrogate with them. It's just that easy. That's not to say that an attorney cannot be useful during the course of the estate administration process. There's a lot of things for which we can be used. But I've told people in 35 years, I haven't had anybody leave me as a beneficiary in their will. So we shouldn't be treating ourselves like beneficiaries through obnoxious.
Maybe year 36 is the one, Tom.
That could be it.
Yeah.
That could be it.
So why are people so afraid of probate?
Well, it's because of first, it's the unknown. It's something you don't handle every day.
Right.
And secondly, there is what I call trust mills, and the third is, what I refer to is the internet. So as far as trust mills are concerned, those are non-attorney organizations, and they're pretty much around in every state. And a lot of states are trying to beat them away, but they come with really nice, titles like, Friends of Seniors, something like that, or, senior assistants. And what they wind up doing is they say, don't spend any money on legal fees with lawyers. We're going to come and take care of everything for you. Ironically, they all come with a living trust in New Jersey. They all come with a trust that actually involves tax planning, which virtually nobody needs anymore because the federal estate tax exemption is $13.99 million per person, and we don't have a New Jersey estate tax anymore. I mean, the documents I wouldn't use to wrap a fish with. However, they actually charge, ironically, just as much, if not more, than even a top-tier attorney for good work. But what they wind up doing is what I call the 1-2 tango. After they get your trust to set up a living trust, when they're at the signing appointment, they say, hey, you know what? We should make sure that your assets are secure. And quite frankly, that means 9 out of 10 times the security of the assets is liquidate everything you have, and we're going to put it into an annuity. And the reason they do that is because the commissions give or take about 8%. So, the person who's selling it's going to make the money. If the client makes the money, it's oftentimes a happy accident. That's not to say that all annuities are bad, but there's time and a place for the sale of them, and these people are doing it solely as a scam. Now, what they wind up doing is they tell people that you have to have a living trust for a variety of reasons, such as probate, takes months in New Jersey. Well, as I just said, it's 10 days after death. That it costs thousands of dollars. Well, the filing fee is $175, probably tops. My favorite one, of course, is that the attorney who wrote the will must be used to handle the administration of the estate, and they get paid like $65,000. To which my response has always been, if that was the case, I'd handle 3 or 4 files at the beginning of the year and spend the rest of the year in Costa Rica. It's just not going to happen that way.
Yeah.
So there's a lot of scam artists that try to frighten people into making bad decisions.
Yeah.
And the third is the internet. I've told people that the best thing that's happened over the last 30 years is the internet, and the worst thing that's happened over the last 30 years is the internet. I mean, my wife and I don't go out shopping for Christmas or any other occasion. We just jump on Amazon or some other website, and after a couple of mouse clicks, something's mailed out and delivered. On the flip side of the coin, the information that you get kind of reminds me of the old show Cheers. It's kind of hard to believe it's been off the air for over 30 years, but most people have seen it, even the younger generations in reruns. But one of the characters on the show was a guy named Cliff Clavin. He was the mailman.
Yep.
And Cliff would regularly come into the bar, and he'd be spouting off the most nonsense that craziest nonsense you could imagine. And he would treat it like it was the gospel truth. I believe that when it comes to financial advice, medical advice, and legal advice, I think Cliff is responsible for about 80% of what's on the internet. And so people read that and they think, that's how life is. So I think one thing that I've tried to do over the years, and I think a lot of good attorneys do try to do, is dissuade people from the nonsense and tell them what they need to be concerned with, but also the things that they can let go.
What are some of the biggest issues that you see when people try to do it on their own through various internet, whether it's AI or LegalZoom or what have you?
I think when people have the simplest estates, sometimes it can work out. But there are a couple of considerations. One, nowadays, for many people, the assets are disposed half the assets are sometimes disposed outside of probate. I mean, when you pass away if you're single, if you have a house, that's going to go through probate, as will any bank accounts or brokerage accounts you might have. Where if you have IRAs or 401ks, annuities, life insurance, those are going to go to a designated beneficiary. If you own accounts that are jointly held with another individual, they're going to get it regardless of what the will says. A lot of times I've gotten involved in the administration of estates where somebody wanted a specific pattern of distribution to occur, but what they said they wanted in the will and what was happening with their non-probate assets were completely different. So one thing that a qualified attorney should do is make sure that they're properly aligned. The other is that sometimes people are dealing with special needs and circumstances. We have many, many blended families, as I said earlier, and I can't tell you how many times we get the case where it's a second marriage and they each have 3 kids from the prior marriage. The wife dies first, everything goes to the husband, and after they initially had wills saying they're going to divide everything equally between their children, something happens and, the crime of rationalization occurs and the husband gets his will changed, everything goes to his kids when he dies and her kids get nothing. And there are ways that you can take care of a surviving spouse, but not disregard, what's in the best interest of your own children. The other thing is that we have people that have special needs, and I've had individuals that have a disability who receive inheritances, and when they receive those inheritances, they get knocked off of their needs-based government benefits. The most important one typically being Medicaid, which is their insurance. And without that health insurance, they're in a fair amount of trouble because nobody else is going to be able to pick up the tab for them. Years and years ago, when the internet programs came out, I was doing seminars, and someone would always ask me, what do you think about the programs? And I said, they're wonderful. And people would say, well, why can you say that? Aren't they taking business away from you? And I said, 2 things. One, quite frankly, the person that only wanted to spend a little bit of money on an internet program doesn't want to spend money to get their job done correctly through an attorney. So I'm not really losing. That's not the competition I want.
That's not your client. Yeah.
That's not my client. And
Right.
The second, quite frankly, and this is a horrible thing to say, but I've made a lot of money over the years going to courts to fix the things that were broken. In New Jersey, sometimes we do what's called reformation. And oftentimes I'll bring the will to the court and say, look, this is what the guy executed. He really would never have intended for his child to lose their needs-based benefits, but this is what was produced instead. And we're asking the court to go in and change the verbiage to protect the child. Unfortunately, going to court to get things fixed costs a lot more than doing it correctly to begin with.
Mm-hmm. Yeah. Well, interesting stuff for sure. And thanks for joining us on the Estate Blueprint. And don't forget to subscribe and leave us a review. And remember, the best plan is the one that starts today. Tom, so great having you here. Really appreciate all the insight.
All right, great. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.